Good afternoon. It is now 12:01. Welcome and thank you for joining us for the second installment of our IP Summer School series. This session today is going to be led by Ryan Simmons, and he will be exploring how artificial intelligence is reshaping the patent landscape and what your business should be doing differently as a result. I'm Haley Cook, Marketing Coordinator of Events here at Ward& Smith, and I'll be your moderator this afternoon. If you have any issues with your video or sound quality during the presentation, please reach out to me via the Zoom chat feature at the bottom of your screen, and I'll be happy to troubleshoot with you. This webinar is being recorded. We actually post them all on our past webinars link on our website. They are linked to YouTube. So you can send it to a friend. In addition, our speaker, Ryan, is happy to take questions today, and you're welcome to put those into the Q&A box or into the chat box that you see as well. And he'll either address those during the presentation or at the conclusion of the presentation. As I mentioned, our speaker today is Ryan Simmons. He is a patent attorney in our New Bern office. And Ryan, I'm just going to go ahead and turn the mic over to you.
Okay, thank you, Haley. Yep, as Haley mentioned, I'm Ryan Simmons. I'm a patent attorney. I've been doing this for quite a while, and um, AI is probably one of the bigger events to come along in my 20 or so odd years of patent practice. I kind of come from a background of I spent some years in intellectual property consulting and as well as in-house at IBM for a number of years, and have been here at Ward& Smith for the last 16. But I just want to welcome everyone. Today we're going to talk, about two things: reshaping the innovation landscape simultaneously. It's patents and artificial intelligence. We'll look at how AI is changing the process of obtaining patents, what some of the risks are for practitioners and their clients, and how businesses should be thinking about protecting their innovations in an environment where the rules are honestly still being written. So why does this conversation matter now? Well, it wasn't too long ago, AI in patent practice was just the topic of future of law type conferences. Whereas today it's a practical question that practitioners and clients are navigating in real time. The USPTO has weighed in, Congress is paying attention, and businesses are making critical investment decisions based on what the patent landscape looks like going forward. The goal today, hopefully, is to give you a grounded view of of where things actually stand. There's a number of AI tools that are actually being used by the USPTO, patent examiners, and IP practitioners. For example, some of you may know, examiners are using AI tools such as similarity search, or sim search to generate search queries for prior art searches in their examination of the patent applications. There's a USPTO pilot, the ASAP pilot, which is a program that tests AI efficiency in conducting automated pre-examination prior art searches for new utility patent applications, where you can actually get pre-examination search results if you participate in that program. Use of AI-driven image search tools for utility applications that have highly visual content, and of course design applications. And WIPO, the World Intellectual Property Organization, also utilizes AI for automatic patent and trademark classification. Of course, the AI tools are being used by IP practitioners, including semantic and prior art searching tools such as PatSnap, the Lens. Use it for generative AI tools such as Deep IP, Solve Intelligence. You can use those for drafting patent claims, generating office action responses, mapping prior art. Uh, some of the Microsoft Word, for example, add-ins to automate proofreading and compliance. Those are things like Claims Master and Patent Bots. Also, predictive AI platforms. Also, one of the examples is Patent Bots. Uh, IP practitioners using this for examiner analytics to track specific examiner grant rates, their historical allowances, and some of the different trends in the various art units at the patent office, and also use it for portfolio analytics, using tools like Cipher, where you can, automatically map and very quickly categorize large patent portfolios by technology or market segment. Additionally, the USPTO has issued guidance memorandums on AI use and inventorship and patent practice, and those, you may have heard of those, the April 2024 guidance on AI use in patent practice, and November 2025, the revised inventorship guidance for AI assisted inventions. So it's clear that AI is changing the speed of innovation, as well as the speed, cost, access, and even strategy of protecting IP. And of course, businesses that understand, and practitioners that understand these changes, will have a significant strategic advantage over those that don't. So how is AI being used in patent work today? Well, back in 2023, there was a McKinsey report that identified the legal sector as having significant potential to realize, pretty sizable productivity gains from AI adoption. Today's AI tools, we use drafting tools for the AI drafting tools for patents, are trained on patent-specific formatting, claim structure, and USPTO requirements. Therefore, the output can be a workable draft of, patent application, or, some arguments or responses to a office action within seconds of entering, a prompt into the AI tool. However, that does not replace the attorney's judgment, but it changes how much attorney time is spent on mechanical drafting and more routine tasks versus, the actual strategic legal analysis. As previously mentioned, prior art research at the USPTO is already currently being done using AI tools. AI-assisted form completion and data collection can automate, most of the routine or administrative tasks that can be time-consuming. For clients, the likely outcome over time, hopefully, and should be, is lower costs and faster turnaround, which could also lead to, broader access for inventors to pursue IP protection. If we can lower the cost threshold, you may actually, allow for greater access to a broader number of inventors. We do have to be aware, though, of, some of the potential pitfalls and traps. While AI can, of course, increase efficiency and productivity, if it's not integrated and, managed correctly, it can have the opposite effect. You might have heard of the ever-looming AI hallucination. I've seen, propose the AI assistant or AI tool will propose, unsupported amendments and arguments. May also propose an overly narrow claim amendment to get around some prior art and office act response. Might miss the crux, or the key of a novel point of the invention. And also, on the client side, client AI assisted generated material can sometimes add additional churn and inefficiencies to the process as well. You might have, competing AI output, and, sometimes the AI response analysis that, may get generated, can be an overly complex analysis report, that, the attorney would have to, go through to check for just some of those things that I just spoke about, some of the AI hallucinations, making sure it's not overly narrowing claims. It's capturing the correct crux of the invention, and the various arguments that it's proposing or amendments are supported in the original application. Um, so those are some of the things you got to look out for. There's a lot of positives, but you got to make sure that it's managed and integrated correctly and understood. I want to talk about the USPTO has released AI guidance, and they've released its two primary guidance memos regarding AI. One on practitioner rules and responsibilities, that was the April 2024, and the other is a revised inventorship guidance for AI assisted inventions, and that was in November 2025. And this is the regulatory framework that everyone in patent practice needs to be familiar with and understand. We'll talk about each of these in turn. The April 2024 AI guidance, you said, is primarily focused on use of AI tools in USPTO practice, and set out what was their initial guidance on AI assisted inventorship. And so some of the key takeaways from the 2024 guidance was, first, all AI use is allowed. So they made that clear. The USPTO does not prohibit practitioners or parties from using AI tools in practice before the USPTO. Reaffirms that existing USPTO rules still apply. That is, the guidance does not create a new AI specific rule regime. Rather, it explains how existing tool duties apply when AI is being used. It reinforces that human accountability remains. Any AI assisted filing must be reviewed by the person presenting it, and that person remains responsible for the filing's contents. So those requirements still apply, and those are statutory requirements. AI output must be verified. Practitioners must check AI-assisted factual statements, legal arguments, citations, and evidence before submitting them to the USPTO. And that's important because sometimes AI wants to make the user happy, and it will present arguments that will best support the direction your prompt was. So there's also no general duty to tell the USPTO that AI was used, unless, however, the USPTO specifically requests that information, or the AI use is material to patentability. Familiar with the rule that those involved with a particular patent process or application are required to disclose things that are material to the patentability of that particular patent application. USPTO papers must be signed by a natural person, a human being. AI systems cannot obtain, a USPTO account or act as a USPTO electronic filing user. The guidance also provides a reminder that confidentiality and data security are major risks, and cautions that using AI tools may expose client-sensitive or technical information to third parties, model training, or data breaches. And also, along that same line, provides a reminder that export control and national security issues have to be considered. AI tools using foreign servers or non-US personnel could potentially create export control, foreign filing license, or secrecy order concerns. The 2024 memo also provided what was the USPTO's initial AI inventorship guidance, but that was rescinded and replaced with the 2025 guidance. So kind of the bottom line from the April 2024 guidance was from the USPTO is, use AI carefully. You can use AI as a tool, but you must maintain that human review, professional judgment, and confidentiality protections and responsibility for all USPTO submissions. The 2025 memorandum, which was the revised AI inventorship guidance, essentially rescinded and replaced all the AI inventorship guidance that was in the April 2024 released memo. Um, you know, it establishes that there is no special inventorship standard for AI assisted inventions. The same legal standard applies whether or not AI was used. That is, only natural persons can be inventors, and AI systems cannot be named as inventors or joint inventors. Conception remains the core test for inventorship, with the key question being whether, operative word there's human, had a definite, complete, and particularized understanding of the claimed invention. It sets forth that USPTO views AI as a tool similar to laboratory equipment, software, or research databases. Affirms that AI may generate ideas or assist the inventive process, but confirms that a human must have conceived the claimed invention. It also clarifies that the Pinal factors, which were applied in the, what now rescinded 2024 memo, apply only when assessing joint inventorship among multiple natural persons, multiple humans. It has nothing to do with AI. So that was that each alleged human joint inventor must have contributed in some manner to the conception or reduction of practice of the invention, have made a contribution, and do more than just merely explain a well-known concept. The 2025 memo further states that applications listing AI or another non-natural person as an inventor may, and likely would be rejected, by the USPTO. It also states that priority claims require at least one common natural person inventor, so at least one common human inventor between the U.S. application and the prior filed application. So, kind of the question that might pop up is what happens if a U.S. application, claims priority to a foreign application listing AI as an inventor, and the foreign jurisdiction maybe recognizes AI as an inventor. I don't know of any that do, but there would be a potential conflict there. So, bottom line from the 2025 USPTO memorandum is that AI can assist invention, but patent inventorship must be grounded in human conception. So remember, if you use an AI tool in preparing a patent application, and you do not review it carefully and file it, you are certifying the accuracy of statements you did not independently verify. And further, the guidance does not prohibit AI use as a tool. However, it does require that a human being remain accountable for the substance of every submission, and reiterates that only natural persons can be inventors. Oops, sorry, I jumped ahead there. So, regarding what AI cannot do, the USPTO, and this is a bright line that practitioners need to understand clearly. And this was made clear in the USPTO AI guidance memos. An AI system cannot use your USPTO login. You can't hand your login credentials to a AI tool and have it file documents in your name. You can't create a shortcut and have the AI automate that process. While you can use AI tools as an assistant, autocomplete forms, draft documents, those types of things, the USPTO account represents your personal certification and accountability, and you are personally responsible for the AI's actions. So accordingly, any automation that touches these systems must have a human in the loop at the point of submission. And this is an area where technology is moving lightning fast, and maybe quicker than some practitioners' awareness of the rules govern it. So an area to be cautious with. And so who owns an AI generated invention? This is kind of one of those cutting edge questions in patent law right now. And this has been, somewhat addressed by the USPTO and its memorandums. The two fundamental patent law principles or underlying principles here apply here. One, absent a transfer of one's inventorship rights, such as an assignment, the inventor is the owner, or the inventors are the owner. And two, an inventor must be a natural person, a human who contributed to the conception of the invention. And the Federal Circuit has also definitively ruled that AI cannot be an inventor under current US law. Thus, a fully AI conceived and enabled invention lacks a human inventor and is therefore, not a patentable invention. However, that does not mean AI assisted inventions can't be patented. The key word is assisted. In fact, the USPTO specifically stated that AI may generate ideas or assist the inventive process. The USPTO again views AI as a tool, such as a piece of laboratory equipment or research data. But what it does mean is that you need a human being who made a meaningful intellectual contribution to the conception of the invention. So can AI invent? Technically, sure. But under US patent law, it cannot be an inventor. The real question may be around what is that threshold? That is, where is the line between human inventorship and AI inventorship? So if your company or client is using AI in their R&D, really need to start documenting how humans are directing and shaping the output, and the input for that matter, into the AI. That documentation may prove critical to establish a true human inventor. And this kind of goes back to one of the, very early, concepts of patent advising and patent law, and is to document what you are inventing and what you're doing as you're doing it. Some other things is, what about data privacy risk? Data privacy is obviously a big topic and of much interest and concern, especially in the world of AI. But the data privacy risk in the use of AI is one that can very easily be overlooked. You sit down with your AI tool and input, a bunch of technical details and some proprietary information, and to search for prior art or whatever the research is you're doing, maybe some R&D research, and lo and behold, you may have just shared all that confidential client or proprietary information with a system that uses it to train its model, and therefore is in the public domain. In fact, the USPTO updated its rules regarding confidentiality back in 2021, specifically because of emerging concerns like this. And so practitioners or IP or patent practitioners are actively required to make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or access to confidential client information. So, given the rise of generative AI, practitioners and R&D folks and have to remain especially vigilant when inputting client data into third-party AI tools to avoid breaching these rules or disclosing confidential information. Many AI providers' terms of service allow them to collect user inputs and outputs, use them to train its models, and even disclose them to third parties, including regulators and et cetera. Under those conditions, as a patent practitioner, if you did that, you cannot reasonably go back and claim that you expected the inputted confidential client information to stay private. So, the practical advice here is fairly simple. Read the data policy of the AI tool that you use and think carefully about what you're sharing before you share it. Pause before you paste. Set enforceable rules with IP specific guardrails in your um, entity. Build safe AI channels with real confidentiality protections. Um, train your teams, and in the case of practitioners, educate your clients, or at least try to, help them understand that there could be a potential issue. Those practitioners, inventors, and companies that act now can keep, reaping the AI's benefits while protecting their most valuable intellectual property. But, those that don't are gambling that, their team or team member will never type the wrong thing into the wrong tool and inadvertently, give up or lose some, confidential proprietary information. So, shifting gears just a bit, for businesses, the strategic question in IP protection, shouldn't just be, hey, can we patent this? But it should rather, should we patent this is the better question. Just because you can patent something does not always mean you should, especially, in this AI world. Um, patent protection requires a disclosure of your innovation and, actually, the actual preferred or best embodiment of that innovation. And once you file, the clock starts ticking on your exclusivity period, and your technical information that you have to disclose will become public record and discoverable. For some innovations, particularly in software and data analytics, trade secret protection may offer stronger and longer lasting protection. For trade secret protection, it requires, an ability, and you have to have the ability to keep it secret, processes, in place for doing so. It should be difficult or nearly impossible to reverse engineer. You have to derive some kind of competitive advantage from it being kept secret. So consideration of AI and its impact is, pretty relevant here because, the faster competitors can independently develop similar technology or reverse engineer your technology, the shorter the practical window of, your competitive advantage that either approach provides. And the presence of AI is accelerating, competitors' ability to do both of these. So factors such as, the pace of technology, the reverse engineer ability, the exclusivity period window that you are looking for, the enforceability or, even the defensibility, the patentability, and with that, what's the likelihood of receiving a patent with, meaningful claim scope, budget, and market and competitor perception are many of the factors to consider in an IP strategy. And, the presence of AI will affect these factors, for example, by accelerating, the pace of technology and the ability to reverse engineer. These will impact, those factors that you have to consider in what you and how you protect that, strategy as to whether, hey, do we look to file a patent to protect this, or to do a trade secret, or just do some kind of, hybrid. These are all factors in understanding AI will drastically help companies that are thinking ahead. So, one of the common mistakes I see is companies treating, IP protection as somewhat of an afterthought, something that they thought about after they already built the product, or, in some cases, even after they already launched the product. But by that point, public disclosure may have already started. Therefore, the clock and some protections may have already been forfeited. the maybe toothpaste may be already out of the tube at that point. You know, my practice includes, advising clients from, Fortune 100 companies to early stage startups. And, the strongest IP portfolios are built by the companies that think of IP protection early and often. They involve their IP counsel during the R&D stage, before anything is shown externally. They strategically think about and match the IP protection type to the asset. They routinely audit, what they have to actively mine their IP instead of taking, what's referred to sometimes as a bubble up approach. Hey, something that looks like a neat invention. Let's file a patent on that, instead of, actively going out and seeing what they have and what's more strategic to pursue. And they file early before external disclosures, and they don't just think here nationally. They take a global look, as appropriate. If of course if you're don't have any market outside the U.S., that's not a consideration, but they do take that into account. I had a client, some time ago that was a very large company, and they would actually hold products for a very long time until their patent received a notice allowance or issued. And that may be taking a little too long, but they were very cautious about that. So those companies, the companies that view IP protection not as an administrative task or overhead budget item, but rather as a valuable asset and a critical part of their company's overall strategic plan and path to success, will have a much greater advantage. And of course, how AI affects that, and can and how they protect it is important to understand, and how it can be used to accelerate and help do that as well. So some of the key takeaways here is, businesses that will benefit most from AI in their IP strategies are the ones that approach it thoughtfully, with counsel involved from the beginning, and routinely. AI is a tool that, used responsibly, makes the patent process, more efficient and accessible. On the flip side, used carelessly, it can create, from an IP practitioner standpoint, professional liability. It could probably, compromise client confidentiality, forfeit valuable proprietary information, and can result in loss of certain IP rights. Um, Happy to continue some discussion here and open up for questions or discussion um, if there are any.
Hey, Ryan. Thank you. We do have one question. For a business owner who has never filed a patent, what is the first practical step they should take if they think they have invented something?
The first thing to do would be to document to some extent. You need to, get some, in my opinion, you need to get something written down on paper to document what the invention is, at least, briefly. And depending on, if you already have a relationship with IP attorney, run it by them to get some input. If not, then you want to really consider, if you know, talking with one. The patent process can be pretty complex, and it also depends on your level of experience with IP. Um, you know, the question I stated earlier was, just because you can patent something doesn't mean you should. And so, if you're a business owner and you have an invention, one question to ask yourself is this have anything to do with my business? Does this further my business strategy at all? Um, and, or is there some kind of competitive advantage to protecting this? And one of the things that your, IP attorney can help you with is to help you walk through that and understand that.
Thanks, Ryan. I think we have one more. Um, if a company is using AI tools to help develop a new product, what should their legal team be doing to make sure they can patent it down the road?
You want to make sure that, they're not putting their confidential proprietary information into an open AI platform. They want to make sure, two things. One, that they are, like I said, the AI can be used as a tool to assist, but you want to make sure you're not leaning on the AI to be the inventor. Um, you know, the AI tool can be used to help with research into those kinds of things, but you'd want to make sure not to let the AI be the inventor. Um, and also, again, going back to the other one of the other pitfalls that you have to watch out for is that you're not sticking that into a database that is being, they're using that inputted data to train their models with and making it available to third parties and make sure you're using a secured AI tool.
Thanks, Ryan. I'm not seeing any more questions in the chat. Last call for questions if anybody has any. Um, Thank you guys so much for joining us. Thank you, Ryan. That was incredibly helpful. I know that this is a confusing and new time, new era in the world. So for those of you in attendance following this webinar, probably tomorrow morning, I'll send out an email with a recording of this session, a link to it on YouTube. Feel free to forward to a friend. I'll also send out this slide deck so that you can access it. Please save the date and look out for an email regarding our next IP Summer School webinar. This will be the third in the series on July 30th. That is going to be with Erica Rogers on our team in Raleigh. And we are so grateful for your participation, and we hope you can utilize this knowledge you've gained today. Thanks so much. That is going to conclude today's webinar. Have a great day, everyone.
Thank you.